Good afternoon, everyone. So here we go again. We're going to talk about somehow a different topic this afternoon. So we're no longer talking about transfers of operational personal data from Eurojust to third country and international organizations, but we're going to talk about transfers of personal data to third countries and international organizations under the Law Enforcement Directive. Therefore, member states, of course, have to enact the directive in their domestic law in order to implement the directive and provide for these transfers. So here we go. First of all, what is the spirit of the directive? Well, that's the general theme here. These transfers are encouraged. The idea is to have, as many of these flows of personal data as possible, but provided, of course, that all the requirements for these transfers are met and all the guarantees are provided for. I understand that URI has already covered this aspect, so I will not dwell further on that unless you have some specific questions, of course. However, in the context of the directive, of course, we're talking about law enforcement. So the circumstances of this transfer are quite specific and differ from the circumstances of transfers under the GDPR. We're talking about frequent transfers in which speed is of the essence. So we're talking about urgent requests for transfers in which very often several jurisdictions are involved. So that's why the directive on law enforcement is supposed to take into account these specificities of transfers in the context of law enforcement. So the scope of the directive includes also transfers from the Union to Interpol and countries which have delegated members to Interpol. This is recital 25 of the directive. This is a new provision if you compare it to the framework decision which was in force before the directive. So that's an important addition to in the directive. Moving on, the principles of general applications which apply to transfers are the general principles of data protection that we know. So I will not, elaborate a lot on that, since again I understand that URI has already covered these areas, not specifically about transfers, of course, but again these general principles apply to transfers as to other areas of the directive as well. So you have to be specific, the principle of necessity. As you can see on the slide, there is no substantial change here if you compare the Law Enforcement Directive to the framework decision which was in place before the directive. You have the principle of essentially equivalence level of protection, similar comments, nothing new under the sun here, and the principle of prior authorization, of course, here of states which have provided the data in the first place. Not really unknown territory here. Further principles which apply to transfers, you have the principle of prohibition of transfer to a third country or international organization which no longer ensures an adequate level of protection. This is a new provision. The idea is simply to, of course, stop all the transfers if you realize that the third state no longer meets all the requirements, so that at least you can deal with the current issues but not additional problems in the future. Records of processing activities is a new provision, of course, because there were no records of processing activities on the, under the former package, let's say, which applied to the protection of personal data before. This is a new element in the GDPR and in the new legal framework on the protection of personal data. Locks as well, there is a new provision on that, which is quite important. I mean, the idea of these locks is that in case you have a data breach, you have a problem which happens in the transfer of your personal data, you can go back and inquire as to what went wrong. You can investigate the matter, and therefore you need to have these locks available in order to reconstitute your processing of personal data and understand what went wrong. And last, transport control, here again, nothing new under the sun if you compare the directive to the framework decision. So again, I will not further dwell on that unless, of course, you have specific questions. So let's move on. Here, I think this is a very important slide about the approach of the directive. As you can see, we have a new architecture in the directive, but not really a new element. And this is, I would say, an underlying theme of the directive. It's an evolution of the protection of personal data. It's not a revolution. So what are these new elements? The first one is that, as a matter of principle, you need an adequacy decision in order to transfer your personal data to a third state. This is the basic principle. If no adequacy decision is available, and as we discussed this morning, there is no adequacy decision available under the Law Enforcement Directive at the moment, your first fallback position is to have appropriate safeguard in place. So we will talk about that in a few minutes. And then if no appropriate safeguards are available, then again, your further fallback position is to rely on derogations, but bearing in mind that these derogations are exceptional. So therefore, they are not supposed to provide a usual basis, legal basis for the transfer of your personal data. So as you can see, this architecture in the directive is pretty flexible, but there are still some requirements to be met. So that's what we're going to talk about now. So again, first principle is to have adequacy decisions in place. I said I would not be talking about Eurojust and Europol this afternoon because it's not the topic. However, there is one thing that I would like to say in respect of adequacy decisions and in relation to Eurojust and Europol. These adequacy decisions are very important to us because, in the context of the new applicable framework, that's again, the primary position, after all the cooperation agreements which have already been concluded and which already have entered into force, for us to transfer also personal data. So therefore, we propose to the Commission to remain involved one way or the other, bearing in mind that we're talking about law enforcement, which is our area of expertise, to guide the Commission to provide some comments behind the curtains, because of course we're not supposed to be in the lead here. The Commission is in the lead, but bearing in mind also that this is a new area for the Commission, not adequacy decisions as such, but adequacy decisions specifically in the context of law enforcement. We did propose to remain involved. We proposed several times. We have not received any clear answer yet, which is regrettable, but hopefully there is a way for us to keep on working together and for us to assist the Commission in doing its work, and especially to the extent that, of course, we have a card to play there, because we need these adequacy decisions to be adopted. Having said that, the criteria for the Commission to issue these adequacy decisions are based, of course, on the existence of independent supervisory authorities in the third states. This is not really shocking in light of the spirit of the GDPR and spirit of the directives. The fundamental rights of data subjects as well are an important factor that the Commission will take into account to issue adequacy decisions. What is very important to bear in mind as well, and that also relates to one of the questions that I've seen in the chat, one of the questions to Daniel this morning, is that even if you have an adequacy decision in place, you still need, for transfers, to meet all the requirements of Article 36 of the directive. What are these requirements? These requirements are first that your transfer must be necessary for law enforcement purposes. Second, that the receiving controller needs to be a competent authority within the meaning of the directive for these purposes. And third, that prior authorization is complied with. And last, that the authorization and the assessment of the originating competent authority in the case of the onward transfer is also available. So not only do you need an adequacy decision as a matter of principle, but in addition, for every specific transfer, all the requirements set out in Article 36 of the directives of the directive need to be met. This is a very important aspect. I mean, the adequacy decision is not a white card to transfer any personal data on the understanding that an adequacy decision is available. You also need to meet the requirements of Article 36. Next, so if you don't have an adequacy decision, as we understand is the situation now under the Law Enforcement Directive, what is the legal basis that you can rely on? Again, your fallback position is appropriate safeguards. So what is meant by that? You need to have a legally binding instrument in place to have these appropriate safeguards in place. So what is meant by legally binding instruments? Well, basically this is a convention, so a contract if you want in contractual terms, and you need to have a bilateral agreement basically between the member states of the EU and the third state. Again, we said that Eurojust and Europol were not really relevant when it comes to the transfers under the directive. Yes, but as you can see, the cooperation agreements which have already been signed and enforced for Europol and Eurojust are relevant criteria to decide on the existence of appropriate safeguards or not. The confidentiality obligations and the principle of specificity also need to be provided among these appropriate safeguards. And of course, if you have death penalty in force or any form of cruel and inhuman treatment in the third state, this is a big no-go. So you will not have appropriate safeguards in this third state. So, I mean, to speak in very broad terms, the human rights need to be complied with in the specific context of law enforcement, which translates into the prohibition of death penalty and any form of cruel and inhuman treatment. Next, if you don't have appropriate safeguards, then you can base your transfer as a legal basis on derogations. Bearing in mind that those are derogations and that therefore they need to be interpreted restrictively. It's not, again, a blanket legal basis to transfer massively personal data under the directive. So they should be limited, these transfers, to data which is strictly necessary. Here I rely on the bottom of the slide, as you can see, on a document of the Working Party 29. So that was a document which was adopted under the old regulation 46, which is no longer in force. However, the reason why I mentioned this document on this slide is that I believe that these considerations of the Working Party 29 remains well relevant when it comes to transfers based on derogation. The spirit of this document remains applicable. So again, these derogations are very well. It's good to have them as a legal basis in the directive, but this is not the principle. So whenever you want to rely on these derogations, you think twice and make sure that the requirements are met. And last, the directive provides for a derogation, which is an optional derogation that member states may decide to translate into their domestic law for transfer of personal data directly to recipients established in third states. So here, I mean, we understand that you transfer the personal data directly to the controller. This is, again, a derogation, of course. It applies in very specific circumstances of urgency. I mean, one of the cases which is mentioned in the directive is cases of terrorism. So it gives you an idea about the very specific cases in which you can rely on this exception. One very important thing is that every time you transfer personal data under the directive, you should document your transfer. Again, this is an underlying theme of all the new data protection package. There's nothing new here. You find similar provisions in the GDPR. you find similar provisions in Eurojust and Europol as well. Why? Well, because that's one of the obligations of the controller to document these transfers in order to explain why this transfer was decided, why the controller considered that all the applicable requirements were met in these cases. And that's also very relevant, of course, in case of inspection audits of the supervisory authority, to make sure that the controller can show that everything was done according to the book, and that there is nothing unlawful about the transfer. That's very important because, of course, the liability of the controller is on the line. So he needs to make sure that this documentation is available to the supervisory authority. And now the final provisions of the directive, which apply also to transfers. Of course, you have some transitional provisions which set out that all the agreements which were concluded before the directive came into force remain valid. Thank goodness, because otherwise, all these conventions would have to be concluded again, and in practice the situation would be unmanageable. But of course, for all the new agreements, they have to be made under the directive, and the directive applies. And last, evaluation and reviews. Article 62 of the directive provides that the application of the directive will be reviewed in due time by the Commission. So then it will be interesting to see what the Commission thinks about the absence of any adequacy decision. And we have to see also, of course, referring specifically to transfers, the use which will be made of appropriate safeguards. Again, adequacy decisions are not available for the time being. Therefore, the next legal basis in line is these appropriate safeguards. I'm not aware of the application of appropriate safeguards so far, but again, we'll need to scrutinize the use of these appropriate safeguards, sorry. So therefore, that will have to be assessed by the Commission in due time as well when reviewing the application of the directive.